we've touched on the adversarial system, the adversarial paradigm. There's another holy cow of the legal system, both Napoleonic and common law, that is a great impediment to effective, efficient governing and conflict resolution. And that's a concept that is known as privacy. The reason that it takes a year to gather all that information that you need to get a warrant to close the crack house is because everywhere you go, you find walls that protect available and relevant information, walls that are called, well, rights to privacy, secrecy, etc. I think it's a self-evident that the more of the relevant information relative to any specific problem or issue that is available, the more timely the information, the more likely the decision that is made is going to be reasonable and fair, intelligent. And privacy, this idea that information can be manipulated, can be censored, can be tailored, can be changed, is used as becomes a form of blocking the necessary information that we need to act effectively. The one thing that we know from system sciences and cybernetics is that information is the lifeblood of all organized forms of organization. And that applies whether it's the vegetable, the animal, or mineral kingdoms. But we're only concerned about the animal kingdom here and the human aspect itself and not the others. But information, the one thing we keep on talking about the human brain, the one thing that the human brain has is access to all information in relation to everything that is happening in the body with which the human brain is charged with managing. And if you look at our system of law, if it's based on the right to censor and withhold information that is relevant to decision making. I got into a very, very interesting discussion with a lawyer about 7 months ago, whom I met at a funeral. The funeral was that of the so-called father of privacy law in the world. I don't know if you're acquainted with the name Alan Weston. No. But Alan Weston is the chap who was really invented and defined the ideas from the legal perspective of what privacy means. The chap that I met at his funeral was his partner. And we got to talking about civil liberties because we're both interested in ideas about life, liberty, and happiness. And I said to him, you know, the greatest enemy to life, liberty, and happiness is privacy. If you can withhold information, then you're skewering the decision-making process. And the more there is ability to censor and manipulate information, the more you're contributing to obscurity and opacity in the decision-making processes of the legal system, which is essential to just society, because that's what we're ultimately talking about. So I think the first thing we have to get rid of, well, maybe the second, but it's a good question as to which is first and which is second, in addition to adversarial mentality, is this idea about privacy. The reason we have privacy is because going back into the 17th century, information was extracted. The courts, government abused people by extracting information from them. So this idea of the right to remain silent, the right not to have to disclose information about yourself, was born out of a sensing that people were using information to abuse others. And if they were denied that information, then the abusers would be denied the opportunity to abuse. But the fact is that The only ones, well, no, I don't want to get into the criminal system because we don't have time enough today to talk about that. But what I'm really saying is freedom of information, and we know that phrase from another similar context, is the most essential aspect of creating a structure of government for today. Information flow, the ability to get access to all relevant information available in relation to any problem that we're considering. And privacy has been the greatest bulwark against that.
You know, it's good that you mentioned this because I worked very actively in the new transparency laws in Mexico. This is one of the few things I did manage to influence in the new government of the Fox administration in 2000. But to my surprise, the transparency laws became very bureaucratic from the beginning.
Very opaque.
Okay? Very, very bureaucratic against my suggestions. But then something else happened that I really don't know how it came about. All the transparency law effort changed immediately somehow into making sure that the privacy laws begin taking hold in Mexico like never before. So we had not even begun with transparency when there was this massive influx of new laws protecting privacy. You know to what degree? To the degree that we do not have, our trials are not public trials. Okay? Judges intervened in our paper trials, and the people are not allowed to peek into a judicial process because the privacy of the defendant could be hampered. Imagine. So you have a divorce and you have no access to what's going on because this might harm the divorcees. Or you sue somebody because they don't pay their bills. Well, nobody's supposed to know about that because you could be harming the reputation of the guy that doesn't pay his bills. It's what you get as a problem in the United States or Canada, we get as a malady, something much worse. So the transparency laws have been overshadowed by the privacy laws that do not allow this community to work. And then we are surprised why the judges are ignored, why only 3% of cases are brought to justice in the criminal law. So, we have a lot to talk about in this regard, and let's not give up. I would